Renting a property comes with a set of rights and responsibilities for both tenants and landlords. Understanding these rights is crucial for maintaining a fair and legal tenancy. Here are some key points every tenant should be aware of. If your landlord does not protect your deposit in a government-approved scheme within 30 days of receiving it, you could claim compensation of up to 3 times the amount of the deposit. Deposit protection schemes are designed to safeguard your money and ensure that any disputes at the end of your tenancy are handled fairly. Always check that your deposit has been protected to avoid any financial issues later on. This rule applies only to assured short-hold tenancies in England and Wales. An assured short-hold tenancy, or AST, is the most common type of rental agreement in England for private residential properties. It typically lasts for a minimum of 6 months, but there is no maximum period set by law. Tenants have the right to stay for the agreed period as long as they pay rent and follow the rules. Landlords can regain possession after the fixed term by giving proper legal notice, usually a Section 21 notice. Additionally, any deposit must be protected in a government-approved scheme. In contrast, a non-AST tenancy, like an assured tenancy, offers more long-term security to tenants. Assured tenancies do not have a fixed term and continue indefinitely until the tenant decides to leave or the landlord can prove a valid ground for possession under the Housing Act of 1988, such as rent arrears or property damage. Non-ASTs might not require deposit protection schemes, and the eviction process is more stringent, making it harder for landlords to regain possession compared to an AST. Your home is your private space, and your landlord must respect that. If your landlord enters your property without permission or proper notice, this could be considered harassment, which is illegal. There are only a few exceptions to this rule, such as emergencies like a fire or flood, which allow landlords to enter without notice. If your landlord repeatedly violates this rule, you may be able to take legal action to protect your rights. It's essential to maintain a written record of any instances where your landlord enters your property without permission or proper notice. This documentation should include dates, times, and detailed descriptions of each occurrence. Keeping thorough records can be invaluable if you need to take legal action to protect your rights. Proper documentation strengthens your case and provides clear evidence of any violations, ensuring that your privacy and legal protections are upheld. As a tenant, you have the right to request your landlord's details. If they refuse to provide them within 21 days, they are committing a criminal offence. Knowing who your landlord is and how to contact them is crucial for addressing any issues that may arise during your tenancy, from repairs to rent disputes. If a landlord fails to provide their details upon request, they can face fines of up to £2,500. Did you know that you have the right to challenge excessive rent increases during a tenancy? Your landlord must follow specific legal procedures to increase the rent. A Section 13 notice is a formal way for landlords to inform tenants of a rent increase. The landlord must use a specific form and give at least 1 month's notice for a monthly tenancy or 6 months' notice for a yearly tenancy. The new rent amount starts after the notice period ends. You can challenge your rent increase if you've received a Section 13 notice and believe the increase is unreasonable, such as if your home is in poor condition due to the landlord's failure to make necessary repairs. You do it by applying to a rent assessment committee, which will decide if the new rent is fair. This process ensures that rent increases are reasonable and gives you a chance to contest unfair hikes. If you receive a Section 13 notice, gather evidence of comparable rental prices in your area to support your challenge. This can strengthen your case if you decide to take it to a tribunal. Additionally, you must not have paid the increased amount to challenge it. If you need detailed information on the subject, there are a few useful links in the description of this video.